Good evening, everyone, and welcome to the World's Law Report. This is Massimo Frigo. I'm an international lawyer, and I'm holding this on my personal capacity, my expertise as lawyer, and this is one of my many tests and the first live vlog on the YouTube. Is not the platform we usually use. We use Facebook, but we thought to give it a try. And also it is another form of vlog. I usually try to do stand-up vlogs or interviews, and this time I'm going to try to make a vlog a bit in the form of a lecture. The scope of tonight is presenting you with the recent ruling, a recent order of the Court of Justice of the European Union that addresses the situation of Poland. Why this is important? First of all, in a sense, of course, this vlog is addressed to jurists, is addressed to lawyers, so you will be familiar with what is the Court of Justice of the European Union. It is the highest court of the EU legal order, and you will be familiar with the competence of the Court of Justice that can receive cases from ordinary court on preliminary questions, but also can rule on infringement proceedings whenever a country does not respect EU law. As you may also know, the situation in Poland and the situation of the rule of law in Poland has been problematic for some time. And there have been many critiques, not only from civil society and the legal professions and the judges in Poland, but also from the European Commission and the EU. There have been a set of decisions already by the Court of Justice on the system that have been criticizing is the independence of the judiciary, the structural independence of the judiciary, which has been undermined by a series of reforms by the current government. Now we are analyzing a particular decision. This decision is actually not really a ruling, it is an order of interim measures. In the case of European Commission versus Poland, and the number you will see it just here. And this is a first because it's the first time, it is the first time that the Court of Justice actually issues interim measures on a systemic issues of rule of law. So interim measures, what are usually? Interim measures are measures that are there to avoid that there is an irreparable harm to the object of the dispute, of the legal dispute. What's the object of the legal dispute of this case is the fact that the reforms of the government created a disciplinary chamber in the Supreme Court of Poland that is responsible now for the disciplinary proceedings against judges of the Supreme Court as a first instance and against any other judge as a court of appeal. What's the issue? The issue is that this chamber was appointed by the Council of the Judiciary, which had also been reformed, and that was heavily appointed by executive and legislative powers and not anymore from judges, from their peers. So it was tainted for lack of structural independence. The European Commission has made a preliminary session on the infringement proceedings against Poland, and then when Poland didn't comply with the recommendations, have launched actual infringement proceedings against Poland. And this is the first step of the judicial infringement proceedings. But for the first time, it is asked that the functioning of the disciplinary chamber be suspended while the judicial case was ongoing. So what interests here is understanding what has actually been the decision and the reasoning of the Court of Justice of the European Union, because partly it can guide us to the legal principles that are going to inform the decisions, but partly are also interesting to see in relation to other countries what are the criteria used to consider a situation as irreparable and deserving the protection of interim measures. So we will actually look into the decision and we will comment it by sharing actually the text. So as you can see, this is the text. You can see that first of all, the Court of Justice refers to prior judgments of the Court of Justice itself. The reality is that the judges of Luxembourg have already assessed the situation, but they did it on a different platform. They did it because a Polish court had issued a preliminary question, meaning has asked the Court of Justice whether under EU law the disciplinary chamber was an independent court or not. Under that procedure, the Court of Justice cannot rule on the national body, but they can give the criteria on which the national bodies can rule in compliance with EU law. So what did the court said? It said that the Article 47 of the Charter, which is the right to effective remedy, must be interpreted in the sense that when there is a case concerning the union law, this must be dealt with by a tribunal which is independent and impartial. And the objective conditions based on which that body has been created and the characteristics and the ways in which its member has been appointed must not be of a nature to create legitimate doubts on the people that are going to be subject to them in terms of external elements or direct or indirect influence of legislative and executive power, or about its neutrality in relation with other interests that could lead to an idea of an absence of independence or impartiality. These are the criteria which actually are derived by the basic principles of independence that we find in international law that have informed that decision. What the Court of Justice said, it told the Supreme Court of Poland to decide itself whether this attached chamber was independent or not. The Supreme Court of the Labour Chamber had actually ruled that, and I'm sorry, the decision is in French because it's not been published in English yet. It's the decision of 8th of April. And as you can imagine, with the COVID measures, translation is probably going to take more time. The Social Chamber and Labour Chamber of the Supreme Court found that there was lack of independence on this disciplinary chamber. However, the disciplinary chamber continued because it has an independent budget and etc. to function and also to start disciplinary proceedings against judges. So in this case, the Commission asked for an interim measure basically to stop the functioning of this body. And what has decided the Court of Justice? So the Court of Justice of the EU has first taken the principles from Article 19, paragraph 1 of the Treaty on the European Union, which is basically the article on access to justice for European Union law. In this article, they have said that based on this provision, member states establishes ways to access effective remedies to ensure that people must find a judicial protection, a judicial remedy for their rights that is effective in all domains that are covered by union law. it is the task of the member states to provide these remedies and these procedures in this domain. And it follows that every member state must, on the basis of Article 19, paragraph 1, ensure that these instances, because they are judicial, must have and fulfill the characteristics and the requirements of an effective judicial protection. The court, therefore, goes on citing the principles that this article is actually enshrining the value of the rule of law, which is stated in Article 2 of the Treaty of the European Union, which are the founding values of the European Union. And it gives to the national jurisdictions the duty to ensure and guarantee the application of union law. And in order to guarantee this protection, the preservation of the independence of these bodies is primordial in French, which means it is at the essence of it, as it is confirmed by Article 47, which is the right to an effective remedy of the European Charter of Fundamental Rights. And it is in this context that the Court of Justice considers that the requirement of independence of judges imposes the fact that the rules of disciplinary proceedings on judges must have themselves the guarantees to avoid any risk that a system like that is used for the political control of judicial decisions. Therefore, setting rules that define the behaviors which constitute a disciplinary offense, or the sanctions, or that foresee the intervention of an independent body, it is and must be implemented based on the right to effective remedy and the fair trial, which is Article 48 of the Charter. And therefore, the requirement of independence is central. As you can see in paragraph 35, the disciplinary regime applicable to judges in national courts must respect the principle of independence of judges and notably guarantee that the decisions given in disciplinary proceedings against judges must be controlled by a body which has itself the guarantees of independence of a court, of a tribunal. Based on this, the Court of Justice built up its own competence and even refused one of the arguments brought by the Polish government, which was, you have never actually ruled that interim measures could be issued in a case like this, so there's no precedent. And the Court of Justice reminded that they don't reason by precedent, and the fact that they haven't really found that there was a need of interim measures in a case like this, which deals with constitutional bodies of a state, was not a reason not to have a first time. For this reason, the court actually goes and decides to take the case to the assessment of the interim measures, and they go on the merit of the case, which means they need to decide whether there is a sufficiently arguable case, the fumus boni iuris, and whether there is the sense of urgency, which means whether there is a need to avoid a grave, a serious, and irreparable harm to the interest of the applicant. So for what concerns the fumus boni iuris, or whether there is an arguable case, the court set up the case brought by the Commission, which said basically that the Judicial Council of Poland has been overhauled. There have been the previous one. They've been all made to resign by law, and that same law changed the composition of the judicial councils to basically bring it to 23 members out of 25 being appointed by the legislative and the executive bodies, contrary to international standards. Furthermore, in that same moment, the new disciplinary chamber was created, whose member had to be appointed by law by the new judicial councils and could not include judges appointed by the previous one. So already that gave a great fumus of politicization of that chamber of the Supreme Court. Also suspicious was the fact that that was the only chambers, contrary to the others, that had a certain degree of financial autonomy from the president of the whole Supreme Court. And finally, the Commission had brought the case that the combined assessment of all these elements gave evidence of a structural break, a structural disruption, in French is rupture, that makes it impossible to avoid any legitimate doubt in terms of independence of the disciplinary chamber, in terms of its exterior element and the impartiality between the parties. So this was the advice of the Commission, based on the jurisprudence of the court. And the court then reminded the principles, and the principles is that the guarantees of independence and impartiality means that rules must exist, and I'm quoting paragraph 65 that you see there, for what concern the composition of the body itself, the appointment of its member, the length of the function of this member, and when they can abstain, when they can be recused, when they can be revoked. And all these rules must allow that any legitimate doubt must be avoided, that people don't have any legitimate doubt in terms of their independence of the judges and of the body, and the neutrality of the body. This is based on the principle of separation of power. You will see the following paragraphs. That is at the basis of the functioning of the rule of law. The independence of the jurisdiction must be guaranteed in relations to the legislative and the executive power. It is therefore important that the judges are protected from the intervention and the pressures from external powers, which could put in danger their independence. I'm quoting, in this context, the rules mentioned before, so the rules of disciplinary proceedings, for example, must, in particular, allow to exclude not only any direct influence based on instructions, so an order, for example, but also any form of more indirect influence that could potentially orient the decision of the judges. This is very important because it really stresses that the systemic issue on the composition of the judicial body can actually have an issue on the independence of the judges itself and the perception of independence that the public can have. We will see another time, probably if there is time, that has not been followed by, for example, the European Court of Human Rights recently. So, based on this, the Court of Justice found that there was an arguable case, that there was a fumus bonis juris based on its own jurisprudence. Then it has to set whether there was an urgency. So whether there was a serious or irreparable harm that is foreseeable. And what is interesting here is that they assess the provisions and they check what is the composition of the court, and they assess the same provisions, the same case brought by the Commission by saying that the composition was already basically polluted by the fact that it was set up by the same body appointed by the executive and the legislative powers, and that this jurisdiction was the only tenet of the disciplinary proceedings on judges, because they were the first or the second instance. And it is basically in one paragraph, you will see it here on the paragraph 90, where they basically simplify the tests in this case. And this says, the simple perspective, and I'm quoting, for the judges of the Supreme Court and also for the lower judges of running the risk of a disciplinary procedure that could lead to going before a body whose independence is not guaranteed. Only this may cause to affect their own independence. It is not important how many procedures have been engaged up to now, or what has been the outcome of this procedure. The fact that they may encounter a non-independent body that they may criticize themselves is actually the serious and irreparable harm there is now. And this would be, and you see it's paragraph 92, a serious prejudice, which by its own nature is irreparable, to the legal system, l'ordre juridique of the European Union, and to the rights of the people that will be subject to it. So in that case, we arrive at the case of the urgency. There is a final test that the Court of Justice does, which is trying to make a balance of interest between the interest of the state and the interests of the interim measure. And it's interesting because there are basically the Polish case is you're gonna try to block a constitutional body. We'll have to issue legislation to do it, and it will be highly problematic from a constitutional order. You can't have a balance of case. So number one, the courts actually faces that very easily by saying that you don't need to eliminate the body yet, at least. You just need to stop the functioning of it, so stop the case in going to it. So there wouldn't be a dissolution of the chamber. And the fact that certain judges that may be already under disciplinary proceedings would see their cases suspended, it wouldn't be much prejudicial for them, even if they would have maybe an excessive length of the proceedings, if that is to save them from facing a non-independent and non-impartial body as the judge of that disciplinary proceedings, and also dismiss the budgetary problem. So definitely he made a balancing that that situation would not be as problematic as the other. And based on all of this, which is actually quite strong as a system to assess the order, they issued the interim order, which basically order to stop the functioning, let's hope Poland complies, of the disciplinary chamber. So no case can get to the disciplinary chamber anymore. And this decision must be communicated to the European Commission. And from that moment on, there shall be a compliance from the Polish authorities on these issues. This, we stress it, is an interim order. So the case is not decided yet. We are not talking about a final case. We are not talking about a final decision. This is just to preserve the nature of the legal dispute. What is really important is that this dispute is going to probably be the one in which there's going to be a final determination whether that body can actually stay the way it is, and what are the implications, and this is really key, of having a self-governance body of the judiciary, like the Judicial Council, and having with a politicized composition, and what that's the pervasive impact on the rest of the judiciary. The Court of Justice seems to have quite clear what is the pernicious nature of that. in the principles that they set up, which actually are established by now some years of coherent jurisprudence of the Court of Justice, they set out what are the characteristics and what is the impact of that. There is an interest of the Court of Justice because, contrary to maybe the European Court of Human Rights, the Court of Justice knows that ordinary courts in the European Union are its own courts. They are the courts which actually guarantee the implementation of EU law and the interpretation of EU law everywhere, not only in terms of human rights, but in terms of commercial law, in terms of private law, in terms of even now of criminal cooperation. And having tainted the independence and impartiality of those courts could have devastating repercussions for the Union order, for the European Union law, but also for the citizens of the European Union. So that is why it's really key to follow this case. The situation in Poland, we know it, is very, very serious and problematic in terms of rule of law. But the repercussions this will have for the legal system of the EU is going to be even stronger. So this is the reason of this first lecture, which I hope was of some interest to you. You can leave comments. I will try to answer to them in next videos if there is any question. And I hope this was just the first of many explanations to try to really entangle a bit more the big judgments of yesterday, today, and tomorrow. Again, from me, from the World's Law Report, thank you very much. Thank you for caring about the law, caring about the rights, caring about the rule of law, and having stayed with us for these 30 minutes. To the next one, and hold on. We're gonna go through this all together and maintaining our rights, our values, and possibly a rule of law. Good night.